First case is matter of Non-Human Rights Project v. Lavery. Mr. Weiss, I believe you're arguing.
Thank you, Your Honor. May it please the court. My name is Stephen Wise, and I first want to thank you for the privilege of appearing on behalf of Tommy, who is a chimpanzee who is being kept in a cage in a warehouse in a town called Johnstown, New York.
Counsel, you want us to grant, well, you wanted Judge Seiss, but now you want us.
Yes, Your Honor.
To grant him immediate release from illegal detention. Is that correct?
Yes, Your Honor. Tommy, in this circumstance, is indeed a person who is entitled.
You assert he's a person. We haven't decided that.
Yes, Your Honor. We do assert that is our position, that he is indeed a person, and he is entitled then to a common law writ of habeas corpus. Now, usually writs of habeas corpus involve adult human beings.
Correct.
But there are many cases that have involved children, for example, slave children in Massachusetts.
But there are no
New York.
writs of habeas corpus, at least in this state, that have involved non-humans. Do you agree with that?
I do agree with that. This is a novel case in that way.
But
however,
even you in your brief, when you talk about individual rights, you talk about the fact that along with those individual rights come responsibilities. And you don't want us to foist any responsibilities upon this chimpanzee.
No.
You just want us to determine that he has the opportunity to be free of this confinement.
The better way to view Tommy would be similar to a human child who has rights. You can't put a little child in a cage, but doesn't have correlative responsibilities.
Mr. Weiss, if I may?
Yes, Your Honor.
Corporations have been treated as legal persons in different contexts. Citizens United, for example, is one case. Can you give any example anywhere where in a habeas corpus context, the word person has been attributed to a non-human being?
A person is not synonymous with a human being. A person means it's someone that the civil law now says counts. They're no longer invisible to the civil law. So we cited other common law countries. An Indian court finds that the holy books of the Sikh religion are persons. And in 2012, there was a treaty between the indigenous peoples of New Zealand and the Crown that designated a river as a legal person. So a legal person is a legal concept. It is not a biological concept, which was the teaching of the Court of Appeals in Berne.
We know that from your brief. Did you ask the owners whether they would just agree to allow you to take custody of Tommy and place him in the preserve? And if preserve's the wrong word, I apologize.
Repeatedly. We even said that we would drop this case if the respondent agreed to move him to a sanctuary. And only when we learned he didn't do that and he was going to move him to some place that was just about as bad as where he is now, then we sought the preliminary injunction, which this court allowed.
And so can we safely assume that the goal of this proceeding is to promote the well-being of the chimpanzee?
No, there's only one goal for the proceeding, because it's a common law habeas corpus proceeding to discharge the chimpanzee if it's not unlawful.
Are you saying that you're not interested in promoting the chimpanzee's well-being?
That is not the purpose of our suit.
Well, then maybe the key here is a legislative lobbying activity to ensure that the statutes are changed.
That is one option. But the courts and the legislatures are co-equal branches here.
Yes, we're well aware of that.
Yeah, I'm sure you are. This reminds me, for example, of the arguments that were brought up in the famous Somerset versus Stewart case, which is part of New York common law, where a slave was made free, and Lord Mansfield understood that he had a judicial duty, as this court does, have a judicial duty to change the common law. Then they went to Parliament.
I have to tell you, I keep having a difficult time with your using slavery as an analogy to this situation. I just have to tell you that.
Let me suggest this, that by referring to human slavery, we are in no way comparing Tommy to any
I
human
understand,
slaves.
but my suggestion is you move in a different direction for the next 2 minutes.
Okay. The abilities of self-determination and autonomy are supreme values within the common law. And these are also the same values that the writ of habeas corpus was constructed over the centuries to protect. And we asked this court to not necessarily find that Tommy is a person, but assuming, as Lord Mansfield did, without deciding that Tommy could be a person, remanding to the court with an order to show cause, and then proceed in accordance with Article 70.
Thank you, counsel.
Thank you, Your Honors.
question. If Kiko were to be let out of where Kiko is currently being held, you're not asking that Kiko go out in the street. You're saying that Kiko would still be confined, but in a sanctuary.
That is correct. Kiko would go to Save the Chimps, which is a sanctuary with islands in a lake.
But he's still going from one confinement, which is bad, to another confinement, which is better.
Much, much better. And his autonomy and his ability to self-determine will be allowed to flourish in a way that it's not allowed to flourish now.
Good morning and welcome. We are here for oral argument by the lawyers in this case, and only they have permission to speak. I thus sign the order in anticipation of hearing both sides address the procedural and substantive issues raised.
First, I want to bring to the attention of the court that my brother was supposed to, and in Massachusetts we call the other lawyer brother and sister, and sometimes judges don't know what I'm talking about. So if it's all right, I'll just refer to him as my brother.
Hearing no objection.
I do not object.
Okay.
Never had a brother.
So without the appellate division decisions. Mr. Wise.
Yeah, yes, we do have something to say about that.
Yes, I think you have to address it. Aren't I bound?
My brother argues that the Lavery and Presti case are binding upon this court. Now, the State versus Moore case states that an appellate determination is binding only if it involves, quote, settled principles of law and legal issues. But the case is indeed ongoing, and we believe that it is reasonably likely that the Court of Appeals will indeed take further review of the Lavery case.
Okay, thank you. We'll turn now to the issue of personhood. Mr. Colston.
Your Honor, there's simply no precedent anywhere of a non-human animal receiving the kinds of rights they're talking about. The exceptions that do exist to legal personhood being assigned to something that's not human, in every instance that they've cited, it's something that in some way relates to human interests, whether it's a corporation, whether a ship is treated as a legal person. We think that really is the principle that's governed the assignment of legal personhood. We think that's what the Lavery Court said, and we think that's the law, Your Honor, and we don't know of any exceptions otherwise, and petitioner hasn't cited any.
Okay, thank you. Mr. Wise.
Your Honor, to say that no non-human animal has ever been the recipient of a writ of habeas corpus, well, until the Non-Human Rights Project began filing these suits, no one had ever asked. And the entire hearing has to be looked at in the context of the extraordinary purpose of a writ of habeas corpus. It is the most important writ in the arsenal of writs that are in the Anglo-Saxon heritage. It's not called the Great Writ, capital G, capital W, for nothing. And the very purpose is to protect autonomous and self-determining beings. But science has shown us over the last 50 years, especially over the last 20, that there are more autonomous beings in this world than just human beings. Chimpanzees are not cabined by instinct. They're self-conscious. They have a theory of mind. They can understand what others are thinking. They understand that they're individuals, that their lives mean something to them, which is one of the reasons why imprisoning a chimpanzee is at least as bad and maybe even worse than imprisoning a human being. Because chimpanzees who are in prison and being essentially being exploited by Stony Brook now, that they don't even know why they're there. These are the sort of things that we would only do to our worst criminals amongst us. And one thing I want to make clear is that our argument is limited, extremely limited, to the argument that Hercules and Leo, these chimpanzees, should be persons solely for the purpose of a common law writ of habeas corpus.
Thank you. Understanding what Mr. Wise refers to as the Great Writ and what it means to us, and I think another judge of this court many years ago referred to it as a powerful and broad tool subject to expansive interpretation, and our understanding that the law evolves according to scientific discovery, social mores, witness marital rights. isn't it incumbent upon the judiciary to at least consider whether a class of beings may be granted a right or something short of a right under the habeas statute, some kind of special status? Thus, why can't a chimpanzee, by virtue of the traits documented in petitioner's exhibits, the expert exhibits, be deemed a person for the sole purpose, as Mr. Wise says, of permitting the writ to the very limited extent sought? Why isn't that an appropriate use of this great writ?
Your Honor, what has been diminished all along in this proceeding is how different it is what they're actually trying to do. How these similarities that they paint, you can talk about 99% of DNA and other aspects that create similarities, but the reality is that these are fundamentally, they are different species. I worry about the diminishment of these rights in some way if we expand them beyond human beings. I also think courts are simply just not going to be equipped to determine where this new line is going to be for these vague categories that, yes, they've given them some scientific heft, but autonomy and self-determining, this just becomes a question of where are we going? And you absolutely are opening the possible floodgates, and it is a great writ, but it's been a great writ for human beings. I think it should stay there, and I think the ramifications are ones that we can't always foresee and could have a dramatic effect, not only on our understanding of how important these rights are to human beings, but in applications that could affect our society in a negative way.
Thank you.